Amendment 1A, Lord Hodgson, Astley, Abbotts.
My Lords, I will be briefer on this one because already Lord Goodhart has had a shot at my fox before he even came out of the trap, so to speak. The purpose is, again, in this clause, to disclosure and representations before contract or variation. And this is to try and draw attention of the consumer to informal resolution procedures, of which mediation obviously is the most common. Mediation compared to legal processes may be, should be, can be user-friendly, less oppressive, quicker, less costly. And all my amendment seeks to do is to require insurance companies to make clear whether or not mediation services would be available. And it's another piece of information that I wish to put before the consumer so that he or she can decide whether or not they wish to make use of it. Now, my newfound friend from the Vale of Glamorgan says this is equally unnecessary because the Financial Ombudsman scheme is a mediation facility. Well, I agree with that. It is certainly one form of mediation. But there are at least a couple of drawbacks to the FOSS. The first is that it is limited to awards of 100,000, shortly to be 150,000, so serious claims could not go to FOSS. And secondly, the name of the Financial Ombudsman scheme means that most consumers think of it in terms of purely financial redress. And of course, financial redress is important and will be important in most cases. But from time to time, more often perhaps than we might expect, my Lords, what people are looking for is an apology. We got it wrong. I'm sorry. They want something to say that actually it isn't quite good enough and that they will do something to improve the situation in the future. And this approach of saying, I'm sorry, doesn't fit well with legal proceedings. Indeed, you have cases where people's insurance has been voided because they have actually admitted responsibility by saying sorry after a road accident had taken place. So all my amendment, my Lords, is designed to do is to provide the information about a wider range of options available to resolve disputes rather than the sledgehammer of legal proceedings. Mediation is one such in which the FOSS represents one strand, and I beg to move.
To attendance of the words printed on the marshal fist.
What the Lord has been saying for this amendment, I would disagree with him insofar as he suggests the Financial Ombudsman Service is a form of mediation. Surely mediation is a procedure whereby you bring opposing parties together and the parties themselves, resolve the outcome. Ombudsman is different because the Ombudsman, when he's heard all the evidence on both sides and so on, will come up with his or her proposal as to how to resolve the dispute. But I'm not very happy about the wording of this amendment due to whether they will provide informal resolution procedures. Because informal resolution procedures can cover ombudsman, can cover mediation, can cover other things as well if one lets one's imagination run wild. But is that helpful to the prospective insured to be told simply that there are informal procedures? And any tin pot insurer, if there are such, could say that they have such a procedure, and it doesn't really mean anything.
Just say that while I'm in sympathy with my noble friend's amendment, I actually agree with Lord Borry that it really is how long's a piece of string, and the amount of detail that one would have to get into to make sure that everything was covered under the heading of informal resolution procedures would be quite off-putting and probably not comprehensive. I worry about that. I think it's much better to know that there is a sort of mediator and then an ombudsman if necessary. But there are all sorts of reasons that you, just thinking in terms of the comment that's been made about somebody's insurance being invalidated, at least not they were guilty before actually being proven guilty. If they said, I'm sorry, after a car crash or something, I worry about it. I just worry that by trying to cover some of it, you wouldn't cover all of it, and it's probably better not to cover any of it and make sure that there are just one or two steps involved in the bill that could actually give the consumer protection.
I hope that the brevity of my contribution on Amendment 1A didn't give the impression that I'm unsympathetic to the noble Lord Hodgson of Astley Abbotts. Of course I'm not. But once again, I find I can't really agree with this amendment, really for the reasons, again, set out by ABA in their very recent letter, that since insurers are already obliged to inform the assured about the procedure through the Ombudsman, it seems to me that basically that the amendment is not needed. And this is exactly the same point which seems to have been taken independently in the email which was received only this morning from David Sanders. I agree with their views and therefore couldn't feel that I could support this amendment.
Well, my lords, I'd like to join the chorus of sympathy with my noble friend's intention underlying this amendment, but it won't surprise him if I don't think, nevertheless, that it's appropriate to adopt it in the bill. And I'll come back to the FOS and say a bit about that in a moment, because I think what the FOS offers and the number of and the evidence of the number of disputes in this area that's going through them is highly relevant. But I think the other area which I just wanted to touch on, which we haven't discussed this afternoon, is the position of the FSA rules and what that already requires of insurers, because the FSA rules do already cover information about complaints handling, including informal resolution procedures. For example, firms are under an obligation, and I'll quote the FSA rule on this, to publish appropriate information regarding their internal procedures for the reasonable and prompt handling of complaints, unquote. And this includes making consumers aware of their right to take a complaint to the FOS. So there is already in the FSA rules measures to substantially cover this area. But moving on to the FOS's dispute resolution service, I mean, this, as the committee well understands, operates as an alternative to the civil courts. Its role is to resolve disputes between individuals and financial firms quickly and with minimum formality on the basis of what is fair and reasonable in the circumstances of a case. Indeed, the FOS have said that and again I quote this time from the FOS, that their preference is to resolve complaints informally, getting both sides to agree at an early stage, unquote. And if we look at some of the data and evidence on what they're handling, last year 4 in 5 of complaints received by the FOS did not progress to a formal dispute. Almost half of complaints were resolved within 3 months and 3/4 within 6 months. At present, the FOS receives and deals with around 1,000 complaints a year about non-disclosure and misrepresentation, and we estimate that only about 20 complaints out of that 1,000 are about disclosure which exceeds the FOS compensation limit each year. And of those 1,000 or so complaints, about half are upheld. It is very rare for complaints to proceed to court. We estimate that only around 3 non-disclosure cases exceeding the FOS limit each year are taken to court. And I think it's worth stressing that the service provided by the FOS is free to consumers, whereas, of course, other forms of mediation are not necessarily free to the parties, who often bear their own costs and share the costs of the mediator. So, my Lords, I say again, I am sympathetic to the aims of my noble friend's amendment, but I do believe between the FSA rules and the way the FOS operates that there is adequate consumer protection in this area, and I would ask my noble friend again to withdraw his amendment.
My Lords, I'm grateful for the sympathy I've had from all round the committee. I did not think that, again, the wording I have chosen would be felicitous or commend itself to the parliamentary draftsman. The noble Lord Borry, I actually was quoting from the Vale of Glamorgan letter when he said that the Second Amendment seems to me to be irrelevant as such a requirement really being through the Financial Ombudsman scheme. I mean, that was my word about his word about mediation, not mine. That was just a strand. I'm very grateful to my noble friend the Minister. I think he's put forward some powerful arguments about the positioning of the FSA, treating customers fairly, the complaints handling procedures, and also some very helpful false statistics about the way, both in terms of numbers and value, and the way they've proceeded. And, of course, the not insubstantial last point, that it is a free service, which is, of course, of great value to consumers. And on that basis, I seek leave to withdraw the amendment.
Your Lord's pleasure, this amendment be withdrawn. The amendment is binding.